few years ago, before he helped organize a deadly white supremacist rally in Charlottesville, Virginia. Augustus saw Invictus send a mass email to his friends, colleagues and acquaintances to announce that he was embarking on a spiritual journey to launch the Second American Civil War. Invictus, who legally changed his name from Austin Gillespie to the Latin for Majestic Unconquered Sun, hitchhiked out west, where he fasted and prayed in the desert.
When he returned home to Florida, he slaughtered a goat and drank its blood.
White supremacist leader Richard Spencer later credited Invictus, who believes white people are facing genocide at the hands of Syrian refugees and Islamic State terrorists, with drafting an early version of the Charlottesville Statement, a political manifesto released at the August rally.
The final version of this document called for a white ethnostate, described Jews as ethnically distinct from Europeans, warned that the so-called refugee crisis is an invasion, and claimed that leftism is an ideology of death and must be confronted or defeated. There are, as the nation learned after the violence in Charlottesville, plenty of white supremacists willing to espouse their views publicly. What makes Invictus unusual is that until recently, he held a position of power and responsibility, one that is supposed to come with a promise that the holder is of good character and respects the rights and liberties of others. He was a practicing lawyer.
In one of his higher-profile cases, Invictus represented Marcus Fiala, the former head of the neo-Nazi American Front, in appealing his conviction for teaching and conducting paramilitary training, allegedly in preparation for starting a race war. Invictus maintains that Fiala was innocent and became close friends with him and other members of the American Front, he told HuffPost.
He also named his law practice Imperium, PA, after a book written by the mid-20th century Nazi sympathizer Francis Parker Yockey.
Invictus retired from the Florida bar in March 2017, just a few months before he helped plan the white nationalist gathering in Charlottesville. But because he voluntarily withdrew from the bar, he can petition for reinstatement at any time.
And he had plenty of ideological company in the legal profession. HuffPost has identified over a dozen current and former lawyers openly affiliated with white supremacist groups.
I first started tracking white supremacist and Nazi lawyers after I received a phone call from Mark Side, a lawyer and a source of mine in Washington.
In the aftermath of the Charlottesville rally, Side, like many other Americans, was grappling with how to confront the far-right extremists who proudly gathered there, seemingly without fear of consequences.
There would be no rebuke from the White House.
Although anti-fascist vigilantes launched their own efforts to bring about accountability, naming and shaming rallygoers and pressuring their employers to sever ties, this ad hoc response was inevitably flawed.
The amateur sleuths got some white supremacists fired. But they also targeted some people who weren't even involved.
And free speech advocates warned that firing people because of their beliefs, no matter how abhorrent, could set a dangerous precedent.
Perhaps there was a better way to hold some white supremacists accountable, Side mused.
Being a lawyer, he noted, is different from most jobs.
Lawyers know their clients' most closely held secrets.
Their actions can mean the difference between people going free or spending years in prison, between victims getting justice or nothing.
In legal settlements that result in financial compensation, the money goes first to the lawyer, who is entrusted to pass it along to the client. And because of their inside understanding of how the legal system works, lawyers are uniquely equipped to protect themselves from charges of wrongdoing.
Because of all this, the legal profession is one of the few that requires members to uphold a certain moral standard.
After graduating from law school and passing the bar exam, aspiring attorneys face a character and fitness test before they can be admitted to their state's bar and practice law.
Lawyers can, in theory, get kicked out of the profession at any time for failing to uphold their state bar association's ethics rules.
The initial character and fitness test is generally treated as a formality. The requirements vary by state, and enforcement can seem ad hoc.
But there are individuals who fail.
People have been denied bar admission because of a past gambling problem, delinquent debt, a substance abuse issue or dishonesty.
Stephen Glass, a former New Republic reporter who had fabricated characters, quotes and events in more than 24 stories he wrote for the magazine in the 1990s, was warned off by the New York bar and later rejected outright by the California bar.
Defining moral character is an admittedly subjective endeavor, but marching with neo-Nazis would seem to signal character flaws.
Although being an avowed racist doesn't explicitly violate the rules that govern lawyers' conduct, it can be a problem, said Keith Swisher, a legal ethics professor at the University of Arizona's Law School.
If a lawyer is truly racist, that presents questions as to whether that lawyer can competently and diligently and fairly all represent clients, he argued.
In practice, it's almost unheard of for aspiring lawyers to be denied admission to the bar because of their ideology or for existing lawyers to be punished for expressing their views.
Privacy restrictions make it hard to know exactly how often this does happen.
The last case to make public waves was nearly 20 years ago, when Illinois Character Committee denied bar admission to Matthew Hale, a white supremacist who said he wanted to be an advocate for white people in the courtroom. But instead of inspiring a border push to root out racists from the legal community, the Hale case and its subsequent backlash may have made bar admission officials more wary of disqualifying people for any reason that could seem to violate free speech rights.